Hey, what's going on guys? Aaron here. Welcome to the video. So in this video, I'm going to talk about the FTX updates over the last couple weeks, including possible changes that will happen with the plan, possible delays of the initial payouts, and also at the end of the video, I'm going to talk about what's going on with Celsius and FTX. Celsius has a really large claim of like over $400 million, and FTX is trying to get that thrown out. So I'll cover that towards the end of the video, but I just want to start out with everything FTX related. So the main thing that's been happening are objections to the plan. There are individuals that have objections to the plan, and Three Arrows Capital has some objections to this plan as well, saying that the plan provides unequal treatment between different classes of creditors or different claims. Next, we have an objection from Louis from FTX Creditor, which I'll talk about a little bit later in the video. He is saying that there is unfair treatment of basically which creditors or which claims will need to provide what information, what KYC documentation. Here he says the debtors, meaning FTX, can basically deprive holders of their claims and therefore not receiving distributions. And this is because there is an ill-defined process of getting KYC information. And a couple more updates before I get to the SEC's objection and then the many US trustee objections. First, we have right here, the examiner is wanting to do additional investigations, and his updated report should be on the docket before September 27th. So there were a lot of people that were upset and confused that creditors would not get the full information from the examiner before they had to vote. And that is indeed what is happening here. Next, we have the SEC. So this one came out of left field for a lot of people. Essentially, the SEC is saying that if FTX is going to use stablecoins, we may have a problem with that. The debtors, meaning FTX, haven't identified yet which distribution agent they will use. But because FTX may distribute stablecoins, which is what they had on their last big update, the SEC reserves its rights to challenge transactions involving crypto assets. Really annoying, right? Especially for people that are outside of the US that may have to use stablecoins as the only way that they can get their distribution. The SEC, because the bankruptcy is obviously done in the United States, the SEC is like, hold up, we don't want people to get stablecoin distributions. So before I talk about the US trustees' 10 separate reasons that the court should deny the confirmation of the plan, I first want to talk about FTX Creditor. So as I'll cover a little bit later in the video, there may be some huge delays, possibly, with getting distributions. So FTX Creditor, they are the largest claim buyer by numbers. They have purchased the most claims out of anyone in the FTX bankruptcy. So if you are curious about selling your claim and then within a day or two getting a USDC payment sent to you, I would highly recommend checking out FTX Creditor. The process is incredibly quick and seamless and professional. Most of it is done here online that you can take care of yourself. And I want to let you know that in 7 days, they are pausing the ability to buy claims. So FTX Creditor in a week will no longer be buying claims. So if you'd like to inquire about selling your claim, I will include the link below for you to go ahead and do so. So let's talk about the US trustee. Now, the US trustee, this is his job to object. The US trustee objects in the Celsius bankruptcy, in the FTX bankruptcy. They are kind of the watchdog because they are supposed to be not on one side or the other. They're supposed to be impartial. So the US trustee has 10 separate reasons for why this plan should be denied, or at least this iteration of the plan. So the first big one is about non-consensual third-party releases. And the big issue, or one of the big issues, is that creditors that did not vote, which is most FTX creditors, a non-vote means that you are automatically opting in to releasing all of these third parties. So the US trustee says that the court has to evaluate whether this plan's releases are consensual under contract law. Merely voting on a plan without checking an opt-out box does not constitute the affirmative consent necessary to reflect acceptance of an offer. So a lot of words there, but essentially how they set up the opt-in, opt-out process, it could just be not legal, and that may pose an issue here. And here, the US trustee says the plan would impose third-party releases and an injunction on various entities without people's consent. So that is the big one here. So the next issue from the US trustee is pretty big as well. It's the fact that voting for the plan essentially settles the terms of service issue. Who owns the crypto, the debtor or the customer? And the issue is that you can't create a settlement or settle a settlement just by voting on the plan. Those should be two separate issues, and the judge may have to rule on this. Here, the U.S. trustee says a plan may incorporate one or more negotiated settlements, but a plan is not itself a settlement. And I want to read this from the U.S. trustee really quick. So, because a settlement requires an agreement between settling parties, Rule 9019 governs only parties that have entered into an express settlement agreement. It is not a blanket provision allowing general settlements to be unilaterally imposed upon broad swaths of claimants that have no formal agreement with any party to settle their claims. Okay, lots of words. Essentially, the U.S. trustee again is saying what you did here to settle. There's a very contested issue that a lot of creditors and massive groups of creditors were fighting for years, right? Essentially, who does the crypto belong to? The estate, which was in fact the case for Celsius unless you had a custody account, or are the assets owned by the claimants or customers? And essentially they're trying to settle this entire issue just by voting. And that's where the U.S. trustee is like, not going to work here. So the next big one is regarding the convenience class. The U.S. trustee said the court should deny confirmation of this plan because the debtors have not shown that the plan treats all creditors fairly. Specifically, the plan would reserve the supplemental remission fund for only the largest 2% of creditors by number, basically those not in the convenience class with claims of $50,000 or above. Under the plan, convenience class claimants are projected to receive around 119% on their claims, whereas customers that are not in the convenience class above $50K are projected to receive up to 143%. The U.S. trustee says that the debtors will have enough cash on hand on the effective date to pay convenience claimants at the same rate as other customer claims. And finally, the U.S. trustee says not paying convenience class claimants what you would pay everyone else does not have a business-related justification at this point. And the U.S. trustee says the debtors, meaning FTX, should demonstrate how excluding convenience class creditors from the supplemental remission fund is reasonable. So this will most likely, again, be determined by the judge. I've heard that some people think they may lower the threshold for the convenience class, so maybe bring the amount from 50,000 down to 30 or 20 or 10. We really have no idea at this point. Now, anything can happen. So these are some really big objections. There are other ones I didn't cover, but a lot of the other ones are kind of more clerical, and taking care of them may be very simple. But these are some big ones, right? We have the unfairness of automatically opting people into the releases without their consent. Then we have the whole terms of service and that being settled under the plan, which the U.S. trustee is like, probably not. And then we have the convenience class, the U.S. trustee saying there's no reason they should be paid less than non-convenience class claimants. So we will see what happens here. And before I head to what's going on with Celsius, the next big dates, we have September 27th or before. The second examiner's report should be on the docket. And then the big one is going to be October 7th. This is going to be the confirmation hearing. So what will the judge do regarding everything that the SEC, the U.S. trustee mostly, and individual claimants have presented as objections? We'll see. Now, the reason I believe the first payment is going to go well into the first quarter of next year is because the plan confirmation hearing is October 7th. They thought that the effective date would be maybe around the end of October, and then the convenience class said that they were going to get their first payment within 60 days of the plan going effective. So the earliest, which it never is the earliest would be December 31st. So with these objections and knowing that everything gets delayed weeks, if not many months past what they say, I really think that the first distribution will happen maybe February, March of next year, but hoping for sooner, but plan for the worst. So let me change tunes, talk a little bit about Celsius really quick. And the first one, this is an older motion on the docket, came out July 10th, but I never officially covered it. So essentially, FTX is objecting to proofs of claims filed by Alex and his wife, Chrissy. Mashinsky, who is responsible for Celsius's downfall, shamelessly seeks to divert more than $2 billion from the debtor's customers and other creditors to himself. Mashinsky is entitled to nothing from the debtors. So this is FTX saying that Mashinsky should not get anything, let alone $2 billion. Mashinsky filed proofs of claim in his own name against the debtors in the amount of $2.15 billion and substantially identical claims in the names of two entities he owns and controls. And finally, they say that any damage suffered by Mashinsky or by any entity he owns or controls is due to Mashinsky's own fraudulent conduct, and therefore the Mashinsky claims are barred by the unclean hands doctrine. Accordingly, the Mashinsky claims should be disallowed and expunged. Now, I don't think there's been any update regarding this, but we will know soon. So the Celsius litigation administrator is also objecting to the confirmation of the Chapter 11 plan for FTX. Because he says, and I'm not going to go through all 17 pages, this will basically hurt Celsius getting their money back or getting the claim they have against FTX back. So some of the issue, which is a little bit confusing, essentially Celsius is wanting those Celsius customers that moved their money off of Celsius and into FTX in Celsius's preference period, so the 90 days before they declared bankruptcy. And there's a lot going on here, but essentially one of the issues is that FTX is not letting Celsius essentially get that money back and then handle the preference cases in Celsius's bankruptcy. Very confusing here, but essentially, right, a lot of customers, or some customers, sent money from Celsius to FTX, or from Celsius to their own wallet and then to FTX. And Celsius is like, hey, that's our property. Technically it is if it's not custody, right? Celsius is like, that's our property. It was sent to you in our preference period, and we want that money back. So that is happening kind of behind the scenes, which only affects very, very few people. But here it says Celsius holds claims against FTX to recover more than $440 million of preferential transfers. So that's a lot of money that Celsius is trying to get back from FTX, and I'll get to in just a second a lot of the pushback from FTX about that. So there is back and forth between the litigation administrator for Celsius and then even the U.S. trustee objecting, essentially trying to get information about those people that sent money from Celsius to FTX, because we have two bankruptcies happening right now, and Celsius wants to make sure that, well, I guess they get as much money back as possible. And that's the litigation administrator's job, is to bring back legally as much value as possible to the Celsius estate. So there is a back and forth there. So the final story regarding FTX and Celsius for today, we have FTX saying that Celsius filed their proofs of claim too late and therefore they should get nothing from the FTX estate. So June of 2023, FTX said that Celsius filed more than 100 identical proofs of claim against the debtors, meaning FTX, asserting unliquidated claims in an amount no less than $2 billion. And Celsius has now abandoned those $2 billion. All right, at least that's handled. But more than 1 year later, and more than 1 year after the claims bar date, so that is the date that you have to submit a proof of claim, Celsius filed the late filed proofs of claim, purporting to amend its original proofs of claim to assert claims to claw back from the debtors hundreds of millions of dollars in purportedly preferential transfers. So I'll explain this in a second, but Celsius insists that these late filed proofs of claim are amendments, but FTX is like, nah, they're not. What they are they are entirely new claims asserting new facts and theories of liability against the debtors. And therefore, these are claims filed long after the applicable bar date, and therefore they are time barred. And essentially, they should all be disallowed. And FTX really jabs Celsius here by saying Celsius has made a habit of bar date non-compliance. In the Voyager bankruptcy cases, Celsius also tried to bring preference claims for the first time against the Voyager debtors 72 days after the bar date, but was prohibited from doing so by Judge Wiles. And just as the Voyager judge did, this court should not allow Celsius to exempt itself from the requirements and consequences of the bar date, especially when here Celsius waited for more than a year after the applicable bar date to improperly assert its untimely claims. FTX is like, yo, these are not modified claims. These are entirely new claims, and you did so way after the bar date. Therefore, we shouldn't give you any of this money. And I think it's over $400 million that Celsius has claims against FTX. So it's no small amount of money at all. And it seems like this is going to be the decision of the FTX judge, right? It's his court, his decision. And I don't know which way he'll go with this. So this is pretty big news actually for Celsius creditors, because getting back $500 million or so of money, that's a large chunk of our claim that customers of Celsius would get back. So that is it for everything FTX related right now. And again, if you are curious about selling your claim, I'll include the link below for you to do so. Again, FTX creditor is going to stop buying claims in around a week. So you definitely want to reach out to them if you are curious about selling your claim, getting that money or USDC in 1 to 2 days. Getting that, you can invest in whatever you want, and you don't have to hang around for the inevitable delays of getting distributions in this plan. So I hope you guys are doing well and enjoy the video. Till next time, guys, talk with you soon, and bye for now.